Is that good for everyone?
Yep.
Wonderful. I'm going to follow along here.
So for like these first two slides, like this first slide, how do you want us to handle this? Just to start like thanking people for attending, or what are people going to do
Um,
with the title slide?
I we can just do,
Well, this can be the introduction, right? Hi,
yeah,
Matt Cole
Okay.
here. Blah 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 blah.
Okay.
I'm with class,
yeah. I mean,
and
we
maybe
don't,
talk
yeah,
about the committee as well. You could spend the first minute, Matt, talking about the committee. This is a result of the committee's efforts. You're chair of the committee.
Okay. The AI Legal Tech Committee, I think it's called.
Yeah, and that you were recently in the Maryland State Bar Association magazine, whatever it's called. And this is something you've been working on and leading for the past year and a half, whatever.
Okay.
all right. Are we good to go?
I think so.
Excellent. Let's uh, let's say hi to our audience.
So should we go?
Whenever you're ready.
Okay. Great. Well, all right. I will start then. Good afternoon. Good morning, everybody. My name is Matthew Cole. I am a partner in Saul Ewing's Baltimore office, and I am an intellectual property and data privacy attorney, and I lead our firm's AI team, and I'm also the chair of the Maryland State Bar Association's AI and Legal Technology Task Force. And today I'm going to be presenting with my colleague Ward Klassen, and I'll let him introduce himself in a minute, as part of the MSBA's Certification in Generative AI for Legal Professionals program. Today we will be presenting session 5 on artificial intelligence, risk management, and governance. And today's program and the other episodes in this session are the results of the AI and Legal Technology Task Force's work. We've been at this now for 2.5 years. And we've undertaken a number of projects to familiarize the bar, members of the bar, but also other individuals who provide support and work at law firms with how to use artificial intelligence in their practice ethically and responsibly, and to identify some of the risks and potential pitfalls of using artificial intelligence that you probably have seen in the news, such as hallucinations. And we're going to dive into all those issues in detail. And with that, I'll turn it over to Ward to introduce himself.
Thank you very much, Matt. My name is Ward Klassen. I'm a Baltimore-based technology and licensing attorney based in Baltimore, and have been working with Matt and his committee over the past 18 months.
All right, next slide, please. And next slide. And so just here is an agenda of the issues and topics we're going to be covering today. We're going to start out with a background on the emerging statutory and regulatory frameworks, and what they mean for the legal profession. We're going to talk about AI vendor risk management and due diligence when your law firm, whether you are at a large law firm with a lot of resources or you're a solo practitioner, things to think about when you are investigating and onboarding and then implementing an AI tool. Next, we're going to talk about some security and data privacy best practices and really how to use the AI platforms responsibly and be respectful of the rights of third parties. We're going to talk about some internal governance policies and procedures. And then we're also going to go into some operational risks, such as hallucinations to human and the loop. Sort of what are the best practices there to mitigating the risks of false or inaccurate information being misused inadvertently by people at law, attorneys, and those who support them at law firms. We're also going to dive into some of the intellectual property considerations around the use of artificial intelligence, and finally, we're gonna end the program with our conclusions and some key takeaways for the audience. So why don't we go right into the next slide, and I'll turn it over to Ward to talk about the EU AI Act.
Okay, thank you very much. The EU AI Act was effective August 1, 2024, and the intent is to harmonize AI regulations across the EU, right? And I think the principal points are that it classifies AI systems into four categories. One, prohibited AI, which is basically those systems where AI should never be used or cannot be used. For example, like remote biometric identification, things like that. The second is high risk uses, which can be health, safety, fundamental rights. Third, limited risk, which includes the use of chatbots, deepfakes, in which the law requires the system entity owners to disclose that they're using and the people are working with chatbots and deepfakes. And then finally, there's sort of the minimal risk, and those uses are things like video games, spam filters. It's unregulated, but they're voluntary requirements the EU hopes you will comply with. Unlike the EU, the US does not have a comprehensive federal law or cohesive state laws. It's a hodgepodge of state laws. Some federal laws seem to be constantly changing based on the political whims of different government agencies. I think that if you look here, when we talk about AI specific laws, perhaps some of the best known ones are in the human resources area, hiring, that there are no innate biases in AI programs when you're using AI to screen and hire employees. Okay. And as I've said earlier, in these high risk systems and consequential decisions, there needs to be great care when you're dealing with things like education, employment, healthcare, insurance, and financial services. So next slide. AI vendor and risk management. Obviously, this is a very, very hot topic. How do you manage risk? Okay, there are unique vendors in the legal tech world, such as GCAI and Harvey. These are applications which have been developed specifically for use in the legal world. However, many law firms are using sort of general nature chat GPT, Copilot for their legal needs. Okay. I think the key here is if you're a vendor, you want to make sure that your product is not being used for high risk projects, and that can include things like in a nuclear power plant, things like that, where there could be a catastrophic loss if there's a issue. How do you manage the risk, right? For example, if you're the customer, you should insist on certain representations and warranties, right? That the product has a level of traceability and has logging capability so that there is a way to see how the result, the output was reached. It's simply not a black box in which there's no way to determine or assess the accuracy of the output. The product needs to be transparent and traceable, as I've said. There needs to be a rep and warrant that there have been no identified biases, because obviously, for example, if you're using an HR application to hire and screen employees, you don't want to be on the receiving end of a lawsuit saying that the product you're using discriminates a certain protected group. And then finally, there should be the general reps and warranties you would normally see. They have the right to grant the license. There's no malicious code within the application. From the vendor perspective, obviously, you want to make sure that you have the required or significant disclaimers so that you can't be held liable, because obviously there is an element of black box outputs, right? That as the vendor, many vendors aren't exactly sure how the results are reached. And so not intended to replace the human element or the customer's good judgment. The vendor doesn't wants to have a disclaimer that the software may contain errors, is not error-free, and may not have accurate results. But I think both sides want to have a certain level of protection, and that they should make sure that the agreement, to the extent it's able to be negotiated, reflects a understood allocation of risk. So Matt, I'll
Sure,
turn it
yeah.
over to you.
Thank you. You raised some really interesting points there. I think I'll start with the last one about the ability to negotiate the agreements. What I'm seeing more in the marketplace now than previously are AI vendors really taking a take it or leave it position, especially on key aspects of a software agreement or an AI software agreement, such as the accuracy or the reliability of output, right? And just to sort of set the stage a little bit, when using an LLM, the information that you put into the user interface is often referred to as a prompt or an input. It's a text-based instruction in which you're asking the model to do something, to take some kind of action. You can also upload documents, attachments, images, Word documents, if you're, for instance, redlining an agreement. And the response that the system returns to the user is called the output. And now, because the AI systems are trained on a variety of information, many of which scrape data off the internet from sources that are not necessarily valid or reliable, such as social media feeds, and also because the models are generally continuously learning, they're also being updated based on information that users submit. And so because the vendors can't or won't guarantee the accuracy or reliability of the output, they really put that on customers to review it. You've probably heard the term human in the loop, right? Which means that taking the output, reviewing it for accuracy, correctness before utilizing it internally or externally. And if you're working at a law firm and you're filing something with the court, you really do need to make sure that you're checking the document to make sure it does not have any hallucinated cases, but also not just hallucinated cases, hallucinated quotes. What you're seeing in a lot of the court hearings and court opinions on this topic is not just an AI system making up a case, but providing a citation to a real case that actually exists, but providing misquoted information, language in a case that doesn't exist. So it's really key to understand what the reliability is of the output, what the vendor is willing to guarantee and stand behind, and then take your risk management, operationalize risk management internally within your law firm and review everything before using it, before sending it to a client. And you probably see on LinkedIn and other social media platforms, there are numerous legal tech companies because the plan is really to have a long-term relationship with a vendor to integrate it into various workflows. You really want to use a vendor that has a reputation for providing ethical products, mitigating the risk, but also has financial health. You don't want to spend all this time and money getting your staff and yourself up to speed and understanding how a system works, to then find that you've signed a contract for a vendor who may not be here or whose product may infringe or violate somebody else's rights, and they have to suspend services, which could be a significant disruption for your business. AI contracts are not uniform. There really is no standard form of agreement. There are certain provisions where the uniformity is taking shape, such as some of the disclaimers that Ward was describing. All the disclaimers are generally vendors will provide the software systems, the AI systems as is, as available, making it really challenging and putting a lot of the responsibility on the customers and a lot of the risk on the customers when it comes to using the AI system and dealing with the output. That's why it really is important to do due diligence and try to understand to the best you can the known risks and limitations of the AI tool. There is a significant difference in AI tools that are general purpose versus those that are domain specific or have been fine-tuned or trained or optimized for a legal use. So you're likely to get better results or accuracy out of an optimized tool that's been customized to be used by lawyers, that's been trained on various legal documents, whether it's leases or privacy notices. You're likely to get better output from using something that's more specific to the task at hand than just a general purpose foundation LLM. So you really have to think about this holistically and from a long-term perspective when doing vendor and AI tool due diligence. So for instance, if you have your standard, software diligence questionnaire, you probably have a supplement for data privacy considerations or a supplement for cybersecurity considerations. You should also consider having a template due diligence questionnaire that deals specifically with questions specific to artificial intelligence, such as data quality, data quantity. Does the vendor have the license to provide the data or train his model on the data? How is customer data going to be used? Is it going to be used to train the model? And what steps, if any, have the vendor taken to mitigate any risks of bias? Ward mentioned some of the high risk uses and some of the statutes that are out there and the regulations as well. And it's really an evolving space, right? I mean, you probably are familiar with the Colorado AI Act, which is really the country's first comprehensive and only comprehensive AI statute that's gone into effect. Other states, and by the way, that statute goes into effect at the end of June, and it's already been amended once, I believe, and there's continued discussion about further amendments before its effective date. Other states have tried to put in place similarly broad statutes or comprehensive statutes, but they've either been vetoed, died on the legislative floor, or have been amended to water down their rights a little bit in states like California and Texas. And then you really have to think about how you're using the AI system. If you're using it for employment purposes, if you're using it for insurance underwriting, you're going to fall into those categories of high risk use and have additional governance obligations that will involve significant documentation, maintenance of information, potentially doing bias audits, doing impact assessments. So, the situation is currently evolving, the laws are emerging, and you really have to understand the use cases that which you're using AI, and also the people that you supervise, how they're using AI, so you don't inadvertently walk into any unintended compliance obligations. Next slide, please.
Do you mind if I pause this just
Sure.
for a second? I want to make sure that I can still monitor everything that's happening here. Let's see.
What do you mean?
I need a window with Riverside going.
Okay.
Yeah. There we go.
So which
Sorry
slide?
about that.
That's okay. We're going into slide 6 next. Or is that 5 next? I'm sorry, I lost count there.
So yeah,
AI addendums is 6.
Okay, perfect.
I picked up sort of late on that last slide. Going.
Yeah, I think you switched a little bit early.
Oh, I did. I thought I was switching late. I apologize. Okay.
Matt was following up on my slide.
I gotcha. I apologize for that.
Okay.
Let's see. We're going to use slideshow. This is.
No.
Not
So now you
being
got to go
helpful.
back. You got to go back a couple.
Okay.
I think we were on AI tool due diligence. Is that right, Matt?
Yeah, I think so. Yeah.
Okay.
Or vendor
Sorry.
risk management. Is that what it
Go to
was?
6. One more. Back one more. There. Yeah.
That one. Okay.
That's
I'm
the-
sorry.
Okay, yeah, that should be the next one.
All right. I'm going to mute myself here and then.
Can you put it back in the prior view just so the font is larger? I think you had the slideshow view before. Okay,
Yeah.
perfect. All right, so Ward, am I jumping on this one or? I'm happy to
This
do it.
was yours.
Okay, I'll take it.
You were following up from the other one, but yeah.
Okay, so whenever you're ready, Chris, let us know where you want us to go.
I muted myself, so I will. As soon as I open it back up, we'll go back again.
Okay,
All right, you're good to go.
okay. And so here on this slide are some of the questions to consider formalizing in a due diligence questionnaire when investigating the risks and potential limitations of an AI tool. And so some of the key questions involve really understanding what is the quality of the model's data. So is it just you probably have heard the expression garbage in, garbage out, right? That what an AI model is trained on has some impact on the quality and nature of outputs. So is it trained on just a whole bunch of unreliable information scraped off the internet? Or has it been fine-tuned and optimized with specific information relevant to your use case that will help it understand terms in your industry, such as the legal industry, or if you're doing something for a healthcare client, right, where a software client or a tech client has a tool been optimized to really understand key terms and terminology in that space to reduce the risk of mitigations. Is the model self-learning, and on what data? Is a 99% chance that the model is self-learning. However, some AI models at one point were dynamic and self-learning and have been made static for for certain reasons. But you need to understand what data the model is learning on. And so AI vendor agreements will often have several different categories of data. The first is customer data, and that can include inputs, but it could also include outputs. And so you want to understand if you're putting in sensitive information that may be confidential information, client information, how is the AI model going to use that information? Is it going to be, constantly training and learning on it? And is there a likelihood, if so, can that information be seen by a third party, end up in another party's output, or be processed by a third party when the client or your counterparty who provide the person who provided the information to you wasn't really foreseeing that you were going to use their data for this purpose. You want to understand how a vendor, what risk management approaches they've taken to mitigate hallucination and biased output. You should ask these questions directly. Have they taken industry standard techniques, for instance, to mitigate hallucinations? Have they audited their system to see if it generates biased output? And then have they gone back and done anything to mitigate that risk? For instance, have they looked at other adverse outcomes? Is it generating unfair and potentially discriminatory results? And then have they taken techniques to really lower the risk of that happening? And then what are my rights if something goes wrong? Is the vendor willing to provide you with some kind of indemnification? Is there a limitation on liability? Does the indemnification rights, are they an exception to the limitation of liability? It's very challenging to get a meaningful remedy if you're a customer of an AI software system. I mean, one of the most common remedies is trying to get audit rights if something does go wrong. But that can be a real challenge, because if you get a report of an audit or you get some kind of machine readable file, you likely don't have the subject matter expertise to really understand what you're looking for. So when you are what you're looking at, so when you are negotiating with an AI vendor, really have to pick and choose your spots accordingly and find the areas that are key to your use and your client's data that you're using. And so another right you might have that if something goes wrong is termination. And when can you terminate, and what are the consequences, right, of termination? And there it leads into how is data handled at the end of the agreement. I've seen a variety of approaches. They can range from anything to, customers' data is returned or destroyed within 30 days at the termination of the agreement. I've also seen AI software agreements in which the vendor is requiring the customer to send a written instruction requesting the destruction or return of data. And then you also have to go back to, where the kind of data that not just I'm submitting, that's not just customer data or client data, but also data that is the byproduct of your use of the AI tool, and how is that going to be handled at the end of the agreement. So when you use an AI tool, it generates usage data, performance data, and vendors want to use this information to improve their services, for fraud monitoring, for abuse monitoring. And oftentimes that kind of data can have personal information such as user credentials. AI systems can learn from patterns of data. So you really want to understand, is the vendor going to promise to de-identify and anonymize permanently all the PII that might be put into the system. Next slide, please.
Well, as Matt has correctly said, that in most situations, or at least many situations, customers have little negotiating leverage, and most vendors are unwilling to negotiate their agreements, except for the largest customers. And if the vendor is very large, they're also very unlikely to be willing to negotiate an agreement with the customer. I think it's important that you focus on the most important issues and not get caught up in secondary, tertiary issues. I think for me, the biggest are privacy. How are they going to protect your data? What are they going to do with your data? How are they going to store your data? And the other is data use and ownership, right? As Matt has said earlier, there's really three parts. There's the input data, the output data, and the prompts, which are the questions that you would pose to the application to get the output data. From a customer and vendor perspective, I think they can all agree that you need to use the data to perform the services that have been purchased. And at the same time, I think it's reasonable for the vendor to have the ability to use the data to improve the product that the customer is using or is licensed. Where you tend to have a dichotomy is, can they use the data to create new products? And vendors obviously have a business. They want to make a profit. They want to grow the business. They want to come out with new products, new technology. And to the extent they can, they want to use the data they're obtaining from their customers to create these new products. Most customers will say, or argue at least, we don't care. We want to have our data used to create the services from the product we've licensed, and we're okay with using the data to improve the product. But how do we, the customer, benefit from a third-party product being developed or an unrelated product being developed, which we will not use and we will not benefit from? And so I think that that's a very, very strong argument. The customer also needs to make sure that it retains ownership of not only its input data, but the output data and even the prompts that they create. Some vendors claim that because the customer was using the vendor's application, that the output should be owned by the vendor. I think this is a weak case. Perhaps, as we said earlier, that you can license the output back to the vendor so that it can create new products or improve new products. But the data going in, the data going out really should be owned by the customer, as well as the prompts that the customer's created to get the output. And I think that they should really insist and argue hard about that, because otherwise, once you lose control of your data, you really are at risk. At the same time, I think customers should make sure they understand the difference between anonymized and de-identified data, right? Where one, the general characteristics of the user have been removed, but in the other, there's no way to reverse engineer. So make sure you understand the difference and you understand whether the data that has been anonymized can be recovered. I think that we've talked about the transparency and the granular details. As Matt has also said, it's really a black box, but make sure you understand about traceability, transparency, and understand how the model works, how the output is obtained or determined, and understand the rights that the customer and the vendor have in each of those situations, right? I mean, here as it says, vendors often consider the model information trade secrets and are unwilling to disclose those to the customers. But of course, the customer needs to really understand, because most customers consider their data obviously to be a highly valuable trade secret and one they need to run their business. Matt, I don't know whether you have anything else you want to add.
Yeah, just a few points. I think you touched on this earlier, Ward, about negotiating leverage and luck. There are many now vendors in the marketplace, and oftentimes the sort of the smaller vendor of an AI tool, you might have better luck negotiating with them because they want a customer, right? And they don't have the business model of some of the larger LLM players. But you also have to understand they have certain constraints, technological constraints and contractual constraints, because their products are often built on some of the larger, more familiar commercial LLMs. And so they cannot provide you with transparency because they don't have access to that information, and that they're not the developer, or their hands are contractually tied with the developer that does not allow them to disclose trade secrets in the negotiation. So I think you really have to do the best you can and just develop as much documentation around your AI due diligence as part of your AI governance program. A lot of the emerging statutes and regulations, like the Colorado AI Act, for instance, and other regulations I've seen in the marketplace, like New York's Department of Financial Services regulations on the use of AI talk about a reasonableness standard. It's not strict liability, right? So if you can demonstrate that you did something called an AI impact assessment, that you did diligence, that you had your AI task force or your working group or your internal committee assess the risk as best as they possibly can, that's going to go a long way to demonstrating you are reasonable. And some of the statutes talk about this as well. If you've taken certain steps, right, it's an affirmative defense. So I think, don't do any of this in a vacuum. Involve the subject matter experts that you have available to you, whether it's your IT colleagues or data professionals, and just document as much as you can, and really do whatever you can to understand how the model works and realize you are at a information and negotiation disadvantage when dealing with the vendors. So next slide, please. So AI addendum. So interestingly enough, many vendors that have existing products with customers are oftentimes rolling out AI features in the middle of the subscription period. And existing SaaS agreements and other software agreements aren't really designed to deal with the AI features from a performance perspective, from a data use and ownership perspective, and also from a risk management and liability perspective. So a lot of companies are creating template AI addendums for when their existing software vendor rolls out a new feature. And so the AI addendums are dealing with some of the AI specific issues that we touched on earlier, such as ownership of inputs and outputs, how the vendors can use certain data, how they can treat data, whether they have an obligation to de-identify or anonymize. And not only that, things like they will make promises not to re-identify user information, customer information, or any personal information. And so the AI addendum really serves the place of a like almost like starting from scratch when you're negotiating an AI agreement to deal with some of these AI questions, because that you want to use these features because they're going to give you an advantage, and you don't want to be one step behind your competitors or your peers in the marketplace. So it's now becoming a best practice to have at the ready your own AI addendum, and you can negotiate that with the AI features. They'll have various definitions specific to the AI technology, and one of the key things to know when negotiating an AI addendum is aligning the various definitions of the data groups in the AI addendum with the underlying software agreement, so that way you don't have any misalignment on what constitutes customer data or client data, and how it can be used. You're going to see a lot of like ambiguous, in my opinion, phrases in AI agreements to do things like improve the services, to perform the services, to use data for any lawful purpose or as allowed by law. What does that really mean? How is that in practice? Is that almost an end around a vendor's promise not to train on customer data? And so you want to have an AI addendum sort of ready to go to negotiate when a vendor rolls out a new AI feature, whether it's something in beta testing and you want to understand what are the risks of using a beta feature, or if it's a full-fledged new AI feature, and you want to have AI specific protections, including around performance, right? Because typical SaaS agreements talk about things like uptime and availability, and really those kinds of traditional performance metrics don't apply to AI because of the risk of hallucinations, the risk that AI models might degrade over time. The AI model might be available to you, might be available for use 99.5% of the time, but if it's not operating as intended, if it's generating material or systemic hallucinations or systemic biased output, then you have a performance problem. If you notice the model's output has degraded over time, AI models typically don't degrade overnight. It can happen over many months. AI vendors are constantly rolling out new features, model updates that might have a different response or treat your data differently when generating an output, and it might result in lower quality output. So you really want to make sure you have some sort of contractual document available to you to deal with all these AI specific issues.
Matt, if I can add one thing, obviously, as more and more vendors are looking to incorporate some sort of AI functionality, and that would have a broad range of meetings. into the agreements. I think prudent customers should put in a clause today saying, you, the customer, may not use any artificial intelligence applications within our existing software license or program, or you need to notify us, right? Customers obviously should be notified if the vendor's now incorporating AI into an existing license. Now, vendors may not agree with that and say, we'll notify you, but we're not going to agree to a blanket prohibition because maybe in SaaS we're on a one-to-many model. We're going to roll out AI for all our customers and we can't make an exception for you. But the customer should be notified if the vendor is implementing AI into an existing program they've licensed.
Yep. Next slide, please.
Excuse me. Sorry.
Well, as we've mentioned, protection of the customer's data is of the utmost importance to the customer, right? And so the customer should ensure that the transmission of its data is encrypted at rest, in use, and in transmission itself. Now, that seems obvious, but I know of at least one vendor where they do not encrypt the data at rest. So make sure that's in your contract and they commit to using the encryption at all times. ISO 42001, is a certification to show continued improvement in the protection of ethical and transparent AI management. I think that's a relatively new standard. Of course, most people are familiar with the SOC 2 Type 2 reports, which is an independent audit verifying security controls. And then, as we've talked about earlier, prohibit, if you're the customer or client, the use of that data or their data for the training foundation A models. Perhaps it can be negotiated. And then, of course, when you're in a multi-tenant architecture, the vendors should be required to segregate the customer's data to prevent across client data leaks. Matt?
I'll just add to that, sort of building on what Ward said earlier. You're seeing a lot of reflex in the marketplace where people are necessarily putting in, you can't use AI with our data, you can't train on our data. And I think, in some instances, that sort of broad-based AI prohibition makes sense. But on the point about customizing or using client data, you really have to be thoughtful about the use case and, are you going to get better results? Are you going to get a more optimized model that's going to give you better output if you do allow training, right, on your data to generate that output? So for instance, if you have a knowledge management database with lots of contracts or leases or something along those lines, right, privacy notices, your forms, and you want to be able to build out a more efficient database that gets you a result more quickly, that has the most current provisions, right? There are situations where you can be thoughtful and you say, okay, I want to train a model, make a customized model using this subset of data because I know, right, it's locked down, there's security representations in the agreement, and it's going to generate better output. So I don't necessarily think it's a black or white approach of you can always use AI to train, can never use AI to train on data. Really be thoughtful when you are negotiating an AI agreement, even before, right, you get to that point, figuring out what your use case is, talking to the folks in your AI governance committee and say, would it make sense in this limited situation, right, to allow the vendor to create a fine-tuned or some kind of optimized model based on our data that we know will get us better results. Next slide, please. So here we are talking about some AI data privacy best practices, right? And of course, protecting the rights of individuals is key. And so when you are managing employees who are using AI, you want to make sure that they are aware of the risks. I mean, it's just a fact that most individuals don't read the terms of service of the software system or the AI platform they're using. You want to limit the processing of personal information to only what is necessary to generate output. You could even internally de-identify, some user PII in prompts and come up with a smart way of doing that. There are also some tools that will identify if a user is putting PII in a prompt and redact it. And so there are available options in the marketplace, but the best tool I think is training and employee education and understanding the risks, right? It is, using an LLM, the risk of data leakage, whether it's IP or here personal information, is high because it's very easy to just copy information from a document, right? Hit Control C, Control V into the prompt, enter, and then potentially it's gone if you don't have any prohibitions on data training, and that information can end up in a model. So you really want to work with your people to make sure that they're aware of the risk. You know, put in your AI acceptable use policy at your organization, at your law firm, at your government agency, advising people of the risk of HIPAA violations or violating other privacy statutes, and also just generally respecting the data rights of third parties. As we talked about earlier, you know, seeing if a vendor will agree to de-identify data related to the use of the AI system, and not just that, but also agree to not re-identify. AI is very good at taking large data sets and re-identifying previously de-identified information. You want to also explore whether your vendor will give you something called zero data retention, which means that if you're submitting information into the LLM, it is not stored or maintained for any like significant period of time. Once it's in and it's processed and you get the output, that information is no longer held by the vendor or held by the system, and that can help with things like HIPAA compliance. So you want to make sure that your use of the AI system, that your contractual terms comply with whatever regulations or statutes you're subject to, whether it's HIPAA, FERPA, GLBA, CCPA, some of the state statutes. But you also want to make sure that the platform's config settings are configured, right, consistent with the contractual terms and your AI use policy within your organization. It's not uncommon for a vendor to agree in a contract they won't train on your data, but then when you go and implement the system, you then have to actually proactively toggle off data training or some other feature. So you really want to look at it holistically, right? Having a strong contract is not enough. It really is an operational exercise to make sure that the system is implemented as per the contract and that your people are using it in that same manner. Do what you have to do from a regulatory perspective. I know that large LLM vendors like OpenAI and Anthropic on their websites, they talk about how they will provide a BAA if you are subject to HIPAA. And then, of course, audit trails, right, for data access and movement. Vendors are keeping audit trails. If something goes wrong, right, you want to be able to go back and look at who did what and when. So you can, even internally, right, at your organization, you'll be generating reports to understand who is using AI, what program they're using, what features they're using. And so you want to maintain all of this data. You want to use it to make sure that you are complying with statutes, regulations, your internal use policies, but also because this information is valuable information to you to really understand, are your people doing something called engaging in shadow AI, so going outside their policy, right, using tools or uses that are prohibited. And so really having a robust plan to maintain a documentation of AI use will benefit you by, if there is a regulatory inquiry or if there is an incident, you'll really be able to piece together what happened and what led to the issue.
Yeah. If I can just add to that, I think this concept of privacy by design is just so important, right? When you're dealing with PII, PHI, it's the minimal amount necessary to get the output or run what you want to run, right? And I think prudent vendors don't want your PII, they don't want your PHI. The least amount that you can use to get the output you want is your policy, and it should be emphasized over and over, both to the vendor employees and to the customer employees.
All right, next slide, please. So supervising employee AI use. So here in the first bullet point, we referenced the Maryland Attorney Rule of Professional Conduct 19-305.1, that partners and supervising attorneys are responsible to establish firm policies and really understand how their people are using AI. And we're not going to get into a lot of the ethical implications, but in conjunction with your duty of competence, although there is no in Maryland specific duty of technological competence, you do have a duty of competence. You have to understand the AI tool, right? And at your law firm, it may not just be attorneys who are using AI. It may be attorneys of junior attorneys. It may be your paralegals. It may be your support staff. So you really want to train them, make them aware of the risks, and implement an AI use policy, an acceptable use policy. Part of that is meeting your employees where they are technologically. They're going to have different levels of technological sophistication and knowledge. So you want to, explain the risks to them in a way that they will understand. An AI policy is only good if people read it and understand it. But there are other ways of training. There are ways of, like town halls, small meetings, really face-to-face communications, I find, are very effective. The supervisory attorney should have sufficient technical knowledge to effectively supervise AI augmented legal workflows, right? So that doesn't just mean assigning it to somebody who doesn't know, who hasn't negotiated the AI agreement, right? Someone that has negotiated the AI agreement, done the diligence, they're a perfect candidate to have responsibility. And like, it doesn't have to all fall on one person. If you are larger than a solo practice, it is a very common practice to have working groups and committees and get the perspective of different subject matter experts, because it's really are a variety of risks that touch on different aspects, and you want to bring all those experts to the table so they can contribute their knowledge and help manage these issues, because they aren't necessarily so easily to spot when a AI system starts generating poor output or output starts degrading over a period of time. So delegating tasks to AI, for instance, does not shift the attorney's ethical responsibility. A lot of the cases involving hallucinated briefs, the lawyer simply will say things like, well, I didn't write this brief, someone else wrote it, or I asked the LLM, did it make anything up? And it told me no. So, you're sort of putting yourself in double jeopardy there. So if you are signing something, if you are filing something with the court, if you are using something with sensitive data, client data, either internally and especially externally, you want to make sure that somebody, if it's not you, you assign somebody who's going to review that information to make sure there are no hallucinations, to make sure there are no biased or discriminatory outputs, because you are on the hook if your name is on that filing. And so proactive risk education, I'm a big believer of risk management being proportionate to the nature of the risk, but also tailored to your organization's AI use, but also realizing that the technology is evolving. The use cases you find useful today may not be the use cases that are useful in 6 months. Your AI policy is going to change to account for different kinds of AI uses. I say this all the time. An AI use policy is not set it and forget it, right? Many AI use policies don't even account for AI technologies that companies are presently using, such as AI meeting assistants and note takers. So you should go back and train your people at regular cadences, certainly annually, if not more frequently. If you're rolling out new AI tools within your law firm or your organization, revisit your AI acceptable use policy to make sure it is consistent with the AI tools and the use cases that your employees are using. Set up something called an AI inventory, which is a written document that advises employees within your company of what the approved tools are and how they can use it. And you can set up other AI governance programs like written submissions for AI use, getting a written approval from supervisors, and really thinking about this in in a holistic and thoughtful way. And Ward, you have anything to add?
Nothing to add there.
All right, next slide, please.
Okay, so I think one of the most important fundamentals of having a great outcome from the use of AI is establishing a formal process and policies for using AI tools. And I think the first one is there should be a process for testing and implementing an AI tool before it's being made to your employees, okay? And it should be burned in over 3 or 4 months. And then as a result of that, there should also be clear policies distinguishing and establishing the ability to use AI. So for example, only AI tools approved by the entity, Second, probably not every employee is going to be entitled to use AI, right? And there should be prohibitions on using AI personally if it's not approved, right? And I think there needs to be constant training on this because obviously a bad result could be catastrophic to an entity if there's an improper use of AI. And this training should, in my mind, result with some sort of acknowledgement. Many big companies have electronic training that is required to be done quarterly, semi-annually, annually, with the employees acknowledging in writing that they understand the policy and they agree to be bound by the policy. But I think the most important things we talked about is uh, the approval process for adopting a new AI tool. Unfortunately, so many are available. Anybody can download them to their personal computer. Now, I think most entities have a policy on downloading third-party software from the internet without approval. I think that during the training, there should be examples of all the downsides of using AI improperly. For example, the one that several years ago from Samsung, where a number of Samsung scientists entered in their proprietary and confidential source code into a publicly available AI tool, exposing their source code to the general public, prevented them from obtaining patent protection, but also made their proprietary source code available to the general public. With that, as we've said earlier, that basically AI should not replace human judgment, and any of the output should be reviewed to make sure it's correct. Obviously, there are a lot of stories of hallucinations, lawyers filing briefs with court systems with hallucinogenic sites and statements, which have come back to haunt them. And I think as the courts see this more and more, the penalties are going to increase because now everybody knows this is a realistic possibility, and the courts are not going to accept poor review or failure to review AI-generated materials. And in fact, I saw one law firm was seeking sanctions and fees from the other for having to respond to an improper filing with improper sites from the opposing law firm. So I think that, as we say here, you want to address specific AI tools, the Gen AI systems, the AI note takers, and internally developed tools to make sure that everybody understands the risks, they receive appropriate training on the use of these specific tools, and everybody agrees to abide by the entity's policies and procedures for not only adopting AI, but new AI tools. Matt?
Yeah, and I would just add to that, an AI policy shouldn't be 2 or 3 pages, but it also shouldn't be 27 pages, right? You've got to find the happy medium that really fits your organization and your employee profile, but also really spells out certain things at a level of detail that explains the risk. So identifying what are the permissible use cases, right? Using it for research, using it for email writing, maybe using it for business planning, but at the same time advising users what are the prohibited risks very clearly. So if this is your organization's policy, I'm not saying this is every organization's policy, but there really is no one size fits all approach. Some organizations are allowing their employees to use PII or PHI with enterprise AI models because they have a BA in place, or they have a closed system with certain confidentiality protections. But you can really spell out how employees cannot use AI, right? What information they cannot put in a prompt, and that is a company by company decision. So you may not want employees putting personal information in a prompt. You likely don't want your employees putting sensitive, like trade secrets or other proprietary information in a prompt. You don't want your employees using AI, of course, for abusive or offensive or fraudulent purposes. You don't want your employees using it in a way that's going to generate discriminatory output intentionally, right? And so you really have to lay these out in detail, what an employee can and can't do. And I think an AI policy should also identify the difference between the risks related to a publicly available large language model and a enterprise version, which provides a lot of the contractual protections we talked about earlier, So just to go into this for a minute, publicly available AI platforms, you just go on the website and you sign on to, ChatGPT, Gemini, any of the large providers. There is no confidentiality there whatsoever. So whatever you put in a prompt is out there forever, as Ward mentioned, whether it's trade secrets, whether it's job performance reviews, whether it's anything else that could affect your organization, your colleagues, or even the rights of third parties. And you can contrast that with the enterprise models, which the vendors will provide confidentiality and certain other protections on, like, no data training, for instance. And so, when you're developing in your AI policy, you want to make sure that it's consistent with how you're allowing your employees to use AI. And it doesn't have to necessarily be an all or nothing approach. You can say, well, employees can use publicly available models for these limited low risk purposes, for these limited purposes that do not involve sensitive data. However, if you're going to use it for X, Y, and Z, right, you have to use the enterprise version that has been improved internally, realizing that subscription costs for an AI enterprise model may be expensive. You may not have that many seats or licenses available to your organization. So you really want your AI policy to fit your how you're using AI and your business objectives. All right, next slide, please. And so let's talk for a little bit about the intellectual property considerations. Now, we've talked several times about not putting trade secrets into AI tools that could cause a loss of IP rights, and those are, without a doubt, the publicly available platforms. But even when you have an enterprise version enabled, you really want to understand, right? Does the contract give me the protections, give me the comfort of allowing my people to put sensitive information into the tool? Is there a provision that the vendor won't train on my data? But once you have that, you still have to look at all the ways your people are using AI, because there are other data categories, as I mentioned, one of which is something called feedback. And so in many AI contracts, the vendors will say, if a user provides feedback to us, and that often that term is not defined, we own the feedback and we can use it for any purpose. So let's say, for example, a user puts a prompt in and they get output that is of low quality, or there's something wrong with it. They might send an email or submit a feedback notice to the vendor saying, hey, here's my conversation. I put this in, I was expecting X, and instead I got Y. And X might have sensitive information. Well, if your vendor considers that information to be feedback, they're going to claim ownership of it and use it to train their models, or potentially give it to a third party to train their models. So you really have to be careful about the various data categories and how your people are using it. So you want to make sure there's really no data leakage of your sensitive information into a model where somebody else can see it, and you could be at a loss of losing trade secret protection for non-public information. In the United States, it's now become pretty clear that information that is generated exclusively by artificial intelligence cannot be patented and it cannot be copyrighted, because the Patent Act and the Copyright Act both require either the inventor or the author to be humans, to be individuals. And so getting a patent or a copyright on AI-generated output is very challenging. You have to demonstrate substantial human involvement or significant human involvement and really make a showing and document that the user controlled the process to some extent. The Copyright Office, for instance, now requires a disclosure if a user is seeking a copyright that they did use AI in the process. So, for instance, there was a pretty famous case in 2022 where an author of a graphic novel called Zarya of the Dawn applied for copyright using AI. And initially, the author was granted a copyright protection, but then the Copyright Office did its own due diligence, which is permitted to do under the Copyright Act, and found out that by reviewing the author's social media pages, that she had used an AI system, an AI image generator, to generate her graphic novel. And after learning that, the Copyright Office reversed the copyright and said, no, you cannot get copyright protection because these images were generated solely by AI. So her copyright protection was limited to just the arrangement of these images in the graphic novel, which is what the author did. So you really have to understand that getting patent protection and copyright protection is very difficult. So if you're using AI for some kind of creative purpose or an innovative purpose more specifically, your best bet is probably to keep that information non-public as a trade secret. There's been dozens of lawsuits filed against the providers of AI models for copyright infringement, and those are focused on two different aspects. The first is the training data. If an AI vendor scrapes information off the internet, images, written documents, those might be copyrighted, those are likely copyrighted. And so there's a lot of court cases now assessing whether that information is a fair use, which is a defense to copyright infringement. And the other aspect is if you're the user of the AI and a third party's IP ends up in your output, right, that is a potential risk of copyright infringement. And so what you're seeing now in a lot of AI agreements is that the vendor is willing to provide limited indemnification really for copyright infringement, but you have to be careful in understanding what all the exceptions are to the indemnity for IP infringement. And so if you are, for instance, combining your output with other information, if you are combining the AI system with another service, if you're combining it, for instance, with like a proprietary API feed, you're probably going to, fall within the exception to indemnification. So the protections are there, but they're very limited, and you really have to understand it. So use AI in a smart and meaningful way. As Ward mentioned earlier, it's becoming standard for customers to own their inputs, right? Whatever IP you had in the inputs, assuming you are using an enterprise model, that IP should still be valid. As to outputs, right? As I mentioned just a couple minutes ago, it's unlikely that you're going to be able to patent or copyright your output, but when you are negotiating an AI agreement, you'll want the vendor to assign whatever rights they might have in the output to you to the extent available by law, and that's the kind of language you're seeing now in AI agreements. And you want your vendor's use of customer inputs limited to performing the services, right? You want to control your IP, control your data as much as possible, because vendors want your data. They find value in their data, not just to optimize their service to make sure that it works as intended, but also to develop and improve their AI models for future use and also for other customers.
Well, Matt, if I can add a couple things, I think that was a great overview. If you ask me what are the two most important things when you're looking at intellectual property, make sure your agreement clearly delineates who owns what. I think sometimes this is overlooked and later there's a dispute. So as Matt said, make sure it's clear who owns the output, who owns the input, and who owns things like the prompts, because the prompts can also be very valuable. And then second, if you're the vendor, get the customer or try to get the customer to indemnify you for any copyright infringement for materials in the input that are going into your application.
All right, next slide, please.
Okay, well, here are the key takeaways, I think, and Matt, you jump in as you see fit. Work with established and ethical AI vendors, preferably those that have some sort of focus and have developed products unique to the legal profession, such as Harvey and GCAI. I know there are a lot of great, products being pitched by two guys and a dog working out of Newport Beach. But I think that, it's the old adage in the technology world, you never get fired for buying IBM. And I think that, in this area that is growing and developing and changing rapidly, going with an established vendor, I think will pay off. And then two, I think make sure you vet the AI system, because standard software due diligence often fails for AI. Some of the concerns are not so much with standard software. And then negotiate the AI specific risks in contracts, such as privacy, ownership, compliance. Even though we've said that it's unlikely that the largest vendors will negotiate an agreement, unless you are also a very, very large or prestigious customer, you need to do so. And hopefully, things are changing, as Matt said, that, vendors are realizing in a more competitive environment, they need to make some concessions to customers. and then prohibit client data from training the foundational models, ensure industry-specific security measures that we talked about a little while ago. I would draft clear policies and mandate the human in the loop review, and basically make sure that your employees have been trained on the policy, understand the risk with AI, and I would also have them sign an acknowledgement uh, stating they understand and agree to be abide by the customer's policies. Matt, I don't know whether you want to throw in a few more.
Sure. Yeah. I mean, I think you really have to view AI as something that's going to change over the course of time, and talk to your people, talk to your colleagues, talk to your employees, because shadow AI is a real risk, right? You might have people that are going to websites and, for instance, developing their own AI agents and giving it access to proprietary information, client data, customer data. Um, AI presents unique risks, but I think you have a playbook in place. You don't have to start from scratch with managing AI risk. You can leverage your existing cyber policies, your existing data governance policy, your existing data loss prevention policy, and you want to make sure that they are all harmonized so that your AI use doesn't result in a violation of one of these other pre-existing policies. And then, look at the reports every month of how your people are using your AI tools, because if you're in a larger organization, you may not be getting a lot of traction with your employees about encouraging AI use, or there may be issues with using AI in a responsible way, and really find out who are your AI champions, who are your super users, and utilize them, rely on them to help spread the word internally about using AI to add efficiencies, but doing so in a smart and ethical and responsible way. And just understanding that, a lot of the risk isn't going to come from bad actors, and it's going to come from sloppy employees, inadvertent data leakage, right? So understand, for instance, if you have a mature AI program and you're allowing your company to use AI agents, right? What data sets are being accessed? Is it getting access to email? Is it getting access to stuff that people save locally on their computer that they probably shouldn't be? So really have the conversations with your people, understand how they want to use AI, understanding what tools they are using, and then develop your AI policy to fit the real world business objectives of your company and the use cases that, in 6 months from now and are likely to be different than they are today. It's not, as I said, it's not set it and forget it, but it's one of these areas where we're just going to have to stay on top of the risks, read the news, educate yourself as much as possible, and be vigilant. Be vigilant, and do your best to manage the risk, because if you can demonstrate that you took all the reasonable steps to protect the rights of your colleagues, your employees, and third parties, that's really the best you can do at this point due to the lack of transparency, and the lack of negotiating power. I think with that, I'd like to say thank you for attending today's session. I hope you found it informative and enjoyable.
Excellent. I'm going to stop recording.